All right. Hello, everyone. This is Curt
and Brad Pinsky.
And we are here for another edition of Fire Law Roundup, this time for September 4th of 2023. And Brad, go ahead. Take us away.
Get that squared away. First of all, happy Labor Day to everyone. And for all those laboring, firefighters and EMS workers, dispatchers, as you know, you don't get time off. So Curt and I aren't taking time off. We're coming to you live today. So we figure you deserve to watch us because we know that's what you looked most forward to today. So let's start in Hawaii. This is a really novel, interesting case. The facts are not difficult. And maybe it's dependent heavily on Hawaii's state laws, but look, the facts are simple. There was a underground fire, a brush fire that was burning in 21. And by the way, this is a lawsuit. These are allegations. This is not a court's finding. So we're just reciting what's alleged, not our belief. So as always, there's a brush fire burning in April of 21. Apparently the flames had gone underground, and allegedly the fire department knew it was burning underground, and allegedly they knew that the ground was unstable. A firefighter who had been out on leave comes back, is assigned to the brush fire, and sees it, flaring up every so often. And the captain says, allegedly, go out and, head out there with a fire hose. And then upon walking to the flare up, the firefighter falls into a pit of burning fire, allegedly waist deep, where the fire had been burning, apparently. And there was nothing to support the ground, they claim. They claim that everyone else knew about the dangers, that the department knew about the danger, the chief knew about the danger, the captain knew about the danger, but the plaintiff says that she didn't know about the danger. And effectively, the lawsuit, this is what's key, says that there were reports of 3 to 4 burn injuries suffered by members of the public in this area due to the underground fire, and that the fire department and the other actors were negligent, gross negligent, reckless, because they should have known about the danger and failed to warn and in fact directed, allegedly, the plaintiff to go stand on what they knew was a dangerous place, which raises an amazing legal question, which I think turns out in the fire department's favor. Again, we're not saying, one person was right or wrong, but as a matter of law, my prediction, and Curt, let's talk about this, is that the fire department wins. I mean, we always know there's a danger of something, right? It's hard to imagine that captain knew that specific area was specifically dangerous. And I think that's what it would take to win this case, if it could be won at all. Remember, in most states, there's a law that says all you get from your fire department and your employer are comp benefits, work comp, or maybe enhanced workers comp, but you can't sue for pain, suffering, and everything else. But again, Curt, before I throw this back to you, what do you think? I'm to the point of, unless they knew that specific location was dangerous, there's no liability. It's like saying, look, the house is on fire, we're sending you in. Well, it's dangerous. You just don't know a specific area is dangerous.
Yeah, I think that's a good analysis. And I don't know if you had a chance to kind of go through the complaint line by line. One of the things that struck me was that, Hawaii is different than certainly Rhode Island and New York, and our pleading requirements are different. But the complaint is pled in conclusory terms, like saying that the department was negligent. But we know basically the 4 elements of negligence. And one of them is duty. One of the most important ones is duty. And nowhere in the complaint does it say that either that captain had a duty to warn her, or the chief and the deputy chief were also sued. So I think there's some concerns there about the way it was pled. I think there's some defects there. They stated in conclusory terms that there was negligence, there was gross negligence, there was recklessness, there was willful wanton, and so on. But you're not supposed to get away with just stating things in conclusory terms. Now, maybe Hawaii is laid back in a lot of different ways, and maybe their judicial system is, and which is fine. I mean, that whatever works there. But I was looking for where the legal duty, which is really going to be important for them to establish. I think that gets to your point that I think it's one thing if they didn't like this person and they knew there was a danger and they said, aha, we're gonna get this person, and they allowed it to happen. That's one thing. But I just don't see, I don't know, I just don't see that there's a duty. And there's also, I would think that captain would assume that this person was aware, as the captain was, that this was a problem, a problem area, that they had been there previously. So I think that there's a lot of factual issues there. One of the probably strongest defenses that the department has is the workers' comp exclusivity. And she was a volunteer. So now one of the questions becomes, does their workers' comp coverage provide exclusivity for volunteers? And that'd be over. If it was a career firefighter, I think the case would be, over and done with on a motion to dismiss because of workers' comp exclusivity. That's your exclusive remedy. If you're an employee, you get hurt, that's your exclusive remedy. There are some exceptions, recklessness, and which I just don't see recklessness here. Even gross negligence. I mean, it's unfortunate. It's tragic. We could say maybe it shouldn't have happened, but at the end of the day, at worst, I see negligence. Not, I mean, unless we're missing something.
I don't see how it. Yeah, I'll address your first point. Is most states, at least I know, New Jersey, New York, and many others, the volunteer firefighters benefits are the exclusive remedy, right? So I think that's a tough hurdle to get against her department. So, and I agree. I think the negligence, there's a lot of cases about traps. When you plant a trap, there would be liability, right? And now I've never seen an employer planting a trap or knowingly send somebody into an area which they know is going to collapse, right? But shy of that level of proof where it was intentional conduct, that I intentionally sent you over there, I just don't think this is ever going to get past the motion phase. I would expect that Hawaii is going to come back with a motion to dismiss, saying that, workers' comp barred by the volunteer workers' comp, stating that, maybe the liberal pleading requirements, most courts will let them through that, but who knows? And certainly you haven't alleged. I know I would have gotten,
my father would not have been happy if I wrote that complaint like that. My dad would not have been happy with me.
and it's funny. I was always told you could do notice pleadings, very general. And my complaints are like 30 pages. If you ever look them up, I am so specific. So I agree with you. That's how my father taught me, and that's how we do it. But and look, as things flush out in discovery, so be it, right? But here, I think as a matter of law, this probably gets dismissed. I'm saying that only applying the law I'm guessing is the law in Hawaii. So, but very interesting suit. This would open the Pandora's box that every time a fire department knew there was a heightened danger, like a structure fire in a lightweight truss building, they would say, oh, didn't you know after 5 minutes there's a likelihood of collapse? Well, yes, but we still have to put the fire out. Right here, they still let it put the fire out. What's the other option? Nothing. Do nothing because it's dangerous. Of course, it's dangerous. Our job is very dangerous. So, okay. So I don't mean to any discredit to their lawyer or whatever.
No, certainly no. It's just, I mean, different states are different. And I know Hawaii is laid back in a lot of different ways, and that's one of the things we love about Hawaii. So that may very well be.
Okay, let's come a little bit. Yeah, let's come a little bit back to the coast, and we'll go to California. I'm going to explain what I understand. Maybe you know something more. I don't really understand this well. There's a lot missing from this, from the allegations we know, right? So here's what happened. We have a fire captain. He was out on disability. He returns to disability, but the department has refused to allow him to return to full duty and placed him on administrative leave. He claims, and again, this is a suit, so allegations once again, but he claims that this is because they perceive that he has a disability. The reason he uses that phrase, perceive they have a disability, is because that's also prohibited by the ADA, the Americans with Disabilities Act. You can't discriminate against somebody based on an actual disability or a perceived disability. So he's saying there's a disability that's perceived. Now that's going to be my question is what's the perceived disability? He claims that
it's a seizure.
Seizure disorder.
It's a seizure disorder. Yeah.
Right.
Yeah.
He's guessing, though, I think, and we know why he's guessing that. But in any event, he gets cleared by his own physician, which may not be an ADA issue, but it's certainly the family medical leave entitles you to go to your own physician for FMLA purposes. On the other hand, he had to go to the department's doctor, and the department's doctor then creates some restrictions for him based on a perception of a possible seizure disorder. And they basically say, you've got to get so much sleep on duty. And because you can't get that sleep, you can't be in the fire truck. You have to be on the desk because we can't assure you getting sleep. And he comes back and says that is a attack to a perceived disability, and it bears no rational, my words, not his, bears no rational relation to the perceived disability anyway, which I think is what's being left out is maybe they're saying if you do have a seizure disorder that you increase the risk of having a seizure if you don't get enough sleep. I'm guessing, but I who knows? In any event, the plaintiff claims that this is completely bogus. This work restriction is all just a ruse to keep him out, that no other captain has had the same sleeping requirement, which may be true, but on the other hand, they may not have a seizure disorder either. So in any event, the lawsuit just says that they continue to wrongly perceive the plaintiff as disabled. They put him on administrative leave. They need to return him, and they haven't. Now, I want to point out one thing. No, he hasn't quit, which I think is very important. Don't quit. I keep saying this, but
he must have been listening to you.
Don't quit.
I know you've said that numerous times before. He must have been listening. So
there, I'll take it. In any event, so I have some questions like, did he have a seizure disorder? Who said he had? What was he out for previously? Was it a seizure? Because 1910, the 29 CFR 1910 126 of the fire brigade standard says that, if you have a seizure or a seizure history, you might be prohibited from being an interior firefighter, right? It's unless you have notes from doctors and blah, blah, blah. So having a seizure is right in federal law, or seizure history is right in federal regulations, that it could be an acceptable excuse to keep you out of interior firefighting. But Curt, what's your thoughts?
Well, I think there's a couple of procedural questions that I got, and one of them, what it appears is the department routinely allowed the individual member's doctor to return them to full duty, and which I think many fire departments do. They don't want to have their own doctor, even though 1500 and it says that you should have your own doctor. But at any rate, it seems to allege is that historically the department has always allowed members to put themselves back through their own provider. And so I think one lesson here is for fire departments, what do you do in a situation like this? Because where you become aware that someone's had a condition, and let's assume he did have a seizure or whatever it was that precipitated him being off, became known to other members. And I've been in this situation where people come to me as a chief and they're like, hey, so-and-so had a seizure and he shouldn't be on the truck, and I don't feel safe with him or her, and you need to do something. And if you've routinely allowed them to go on their own medical recommendation, their own doctor's recommendation to return to full duty, now you're in a situation where, how do I justify sending him to our doctor if we've never done that before? So you want to have thought through that and have a system in place that allows you the ability, based on whatever reasonable cause or whatever it is, to have someone go, in addition to their own doctor, go to your own doctor. But if you don't have that, then it looks like because of a perceived disability, you sent him to this other doctor. And now you've got a possible disparate treatment claim right here, just based on that. So without even going further, it looks like maybe we got a problem. In terms of firefighter safety, and I think sometimes we've got to put the laws are good, we should follow the laws the greatest, but above all, our concern is the safety of our employees. And I think that's probably the tack that the department took here. It's a challenge. What exactly do you do? If you have a system, then you just follow the system. When you don't have a system and you're kind of making it up, it looks like discrimination. And it looks like this department was trying to do the right thing, assuming that there's nothing in the background that we are not aware of. It looks like they were trying to do the right thing, but they weren't prepared for it, and maybe they took some steps that were on account of this person's perceived disability.
Yeah, my take on this is right along with yours, that we do often send people to their own physician, and there is a good reason for that, at least one. But I am finding, as you've definitely found, that most fire departments have horrible physical examination, physical and mental fitness abilities, and they don't say what objective findings you can or can't have in order to be an interior firefighter, or in the volunteer world, a driver, fire police, whatever. And there needs to be a physical and mental fitness job description for every single job. Now, there also, as you well know, NFPA 1582, right? We need to 1582, 1583. We need to have we need to have something like the category A and category B conditions. And I know they're admission conditions, but I also use them the way I do it as I make everything a category B once you've been hired, meaning that if you have a condition that you develop after you're hired, you can still work there if the doctor says you can do the job. But those category A and Bs, or they all become Bs, at least provide an objective physician saying, if you have this condition, how does it affect? Right now, here's my problem. Let's take blood thinners. NFPA talks about you can't be on blood thinners, right? Because, as any fire service physician will tell you, if you have a crush injury and you're bleeding, you will die. So not good to be on blood thinners. However, a normal doctor may not be thinking of that. A normal doctor may not think of the chance for crush injury. Maybe they say, oh, I'm just a driver and all I do is drive the fire truck, so doctor, return me. And most of the times, you all know this is true, listeners, that when you go to your doctor, when you're allowed to, and your doctor says, oh, yeah, can you do that? Can you lift 150 pounds? Can you bend over? Can you climb a ladder? Can you wear 60 pounds of gear? You're like, oh, yeah, no problem. Right? There's no real evaluation, and the doctors have no idea. So here's what I am guessing, totally guessing, has happened. It's one thing to say, look, you broke your arm, and your own doctor gets to say, I've removed the cast and the arm is healed. Okay, that's one thing. But it's a different standard saying you having had, and I don't know if this is what it was, you having had a seizure affects your ability to do the job in accordance with our standards. That is rightfully your own fire department physician's role, if your policy says it, to evaluate. So saying you're healed from a condition, broken arm, whatever, is one thing, right? Let their own doctor say they're healed. Whether they then have a condition or a limitation that affects them to do the job, to me, that should be the fire department's physician who makes that, and that's got to be in policy. If that was in policy, they're fine. If not, they're trying to explain to the judge, well, we don't have a policy, but we kind of have a practice. That's my take on this. They wanted their physician to say this is unsafe.
Yeah, we'll see. It's one of those cases. We'll see where it goes, but I think the lesson here for departments that don't have a formal procedure or policy procedure in this regard is to kind of think this through. What are you going to do if you're getting complaints? And I've been there where people come to me and they're saying, I don't feel safe. They had this happen. They had that happen. They're not, I don't care what their doctor says, they're a liability to me. They can't rescue me, and there's no way I'm going to be able to rescue them, and yada, yada.
Yep.
So.
Agree. And I think unions don't always push this, because unions like, oh, we want to go to our own doctor, until the unions want to, kind of keep one of their own out. Then they're like, oh, no, come to our doctor.
And we don't want the department doctor should not be used as a weapon by the department administration. It should be someone who's going to actually have the best interests of the firefighter, the patient at heart. And I'm sure they're all going to say they do, but we know that I've seen it in the past where they go for an IME, and the doctor that's doing the independent medical exam wants to know, how do you want this to come out?
Yeah,
before,
yep,
right?
true.
Before they see the patient. So
Yeah, and you know, I'll tell you the way I do this, just to finish this up, I guess the way I do this in policies is I say, look, it's your own doctor, if they choose, should be able to say whether you still have a condition, whether you're healed, what your limits are. That's for your own physician to diagnose your present medical or physical or mental condition, right? And they say you do or do not have this condition, limit, disease, whatever. It is for the fire service physician, in my best practice world, it's for the fire service physician to say, I'm accepting as true what your independent physician says as to your condition, still has it, doesn't have it, limitations, whatever. And based on what that physician says, here's how it plays out in the fire department, right? So for example, you have a seizure disorder and the doctor says you have a seizure disorder, which is rare, but possible, and it could be exacerbated by certain things. Fine. It's not up to the fire service physician to evaluate the diagnosis, right? But it is up to the fire service physician to say whether that, based on that diagnosis, this person can meet the objective physical fitness and physical requirements. Would you agree with that?
yeah, and I think so. And I to me, I'm more of a consensus kind of person, no matter what I'm doing, whether it's chairing a committee or whatever it may be, leadership. But I think if we can get the two doctors in a conference call, I don't need to know what they talk about. I just need to know we got two doctors, they both agree. And you know, the two of you get in a Zoom room, have that conversation, and don't come out until you give us a yes, he can work, or no, he can't, you know, and let them work that out between them. And if they can't, we'll bring in a third doc to sort of mediate. But I think this is a medical decision. It's not a lawyer decision. It's not a fire chief decision. It's a medical decision that should be made by the doctors. So.
And physical and mental fitness ability should never be used to disguise hatred, discipline, right? If it's a pretext, that's one thing. And look, that's what they're arguing. It's a pretext. That's what everybody always argues. And the question is it a pretext or not? Or am I being unfairly treated differently than somebody else? Those are your two right points. Okay. This is coming up now. We're going to go to Ohio. This is my favorite case. And
we'd have Chip come in on this one.
He should, except he's mourning Jimmy Buffett at the moment.
So, me too.
Yeah, I know. Yeah. I would quote him right now, but I can't come up with a good quote that matches our legal issue. So we'll sail on. So I tried something. So Ohio, let me state why this is my favorite case, because it is so logically correct. It is, I mean, they could have done it in 2 lines, but the court looked to rational, and I'll tell everyone what it is, but the court just looked at one fact and said, here's the obvious conclusion. So here's what we have. The question is, as you pose, right, when does a vacancy occur in an officer's position? So let me start why. The reason this case comes up, before I tell you the very simple facts, is because in Ohio, it says whenever a vacancy occurs in a promoted rank, there's a process. The process is there's going to be a competitive list. If there's no competitive list, other things happen, all within 60 days of the vacancy. So the question here is, was there a vacancy by the actions I'm going to tell everyone about? And if there was a vacancy, then no one disputes, right, that they had to go through with the process, the civil service process. And the union wants the process to be adhere to, which is typically what unions do, right? You wrote the process, you adhere to the process. So that's what they want. So here's what happens. A fire chief retires in a plan. Sort of. I guess the plan was to get him a pension, but he unfortunately, no one thought of this, I'm guessing, except the union, and unions do. They catch this stuff. They know this stuff. Union lawyers, they may not fight fires anymore. But right? So the fire chief retires one day on January 6th of 20, and he's reappointed the following day, all to get him pension benefits or whatever. But the point is, he retired. He submits a letter saying he's retired, and then he's hired the next day. the union argues successfully that once he submitted the letter of retirement, it doesn't matter what happens, there's then a vacancy. And the court just looks and says, and I love how simple this is, you submitted a letter of resignation, there's a vacancy. It doesn't matter whether you're, reappointed the next day or 5 minutes later. The vacancy existed, and that's the end of it. And yet this went all the way up to the Ohio Supreme Court. This was a big deal to look at the obvious fact. There's a vacancy, and the law doesn't say whenever a vacancy occurs for more than a day or more than 2 days. It just says whenever a vacancy occurs, that's it. Well, the vacancy occurred as soon as he resigned. The position's vacant. And it didn't matter whether they appointed the same person, another person, or the person's father or mother. A vacancy occurred. So that's all I have to say about it. I just love how simple this is, and I'm shocked how high this went up in court. I could have won this case.
Well, the chief was able to grab another 3 years. So, but interesting though, what if he didn't resign? What if he didn't retire? What if he just, and I don't know if you can do this, but you retire solely for the purpose of pension, solely for pension purposes. Yeah, I know.
Sounds like you're a little bit pregnant.
But you're going to stay in the position. I don't know. I mean, I think what they were trying to do, and again, what they were trying to do here was allow the chief to remain the chief and collect his basic, I'm assuming it's a state pension. So basically he'd get his salary plus the pension while he served as the fire chief. So
they should have appointed him provisionally while they waited for the exam. That's what they should have done.
Yeah. Well, and I think the pension systems I'm aware of, you can't do this. I mean, this is not permitted. But I'm assuming now they've got a real problem, because according to this, now they've got to appoint someone retroactive back to January of 2020.
Yeah, and what does that do to all the decisions and benefits
retroactive,
and
right? But now, are you going to have 2 fire chiefs? I mean, how are we going to work this one out? So it'll be a little bit of somebody's got a tiger by the tail here. So.
Yeah. Well, good. Look, good for the union. I mean, it's not that I'm a pro or anti-union person. I'm pro the right answer, but the union was right on this. There was a vacancy, and union shouldn't have to be forced to play semantics with it. And I'm not coming out against the fire chief of the department. I get what happened, but you got caught in a procedural snafu. Yeah. So, okay, why don't you head over to
Washington. Wow,
yeah.
this is a developing story. When I first posted about it, excuse me, when I first posted about it, a fire district in Washington, the Benton County Fire District number 1, was scheduling a disciplinary hearing for a firefighter who had a pending sexual harassment lawsuit against the district. She was apparently out on maternity leave. While she was out on maternity leave, she filed the lawsuit based on harassment, and she had done all the things that she was supposed to do as predicates to that. But while she was off, while she was off, she filed a lawsuit. When she came back, they immediately put her on administrative leave pending disciplinary action. And so now she's facing disciplinary action. And this was, what was it? Was last week. And August 29th. And so that was, when I posted it, that was sort of the end of it, that this hearing was supposed to happen on August 29th. Well, August 29th happened and she got fired. And so now she's been terminated. And I would imagine now she is going to be alleging retaliation for having filed a sexual harassment suit. And, I think there's 2 ways that we could look at this. One way is that once someone sued us, we've got to be very careful about how we handle her so that we don't find ourselves in a situation that looks like retaliation, which is what we're in here. And so that's sort of kind of one aspect of it. But let's kind of go with another aspect where maybe we got a problem employee. And certainly I'm not suggesting that we have a problem employee here, but
theoretically,
but where we have a problem employee, and one of the things that they choose to do now, because they're recognizing that, sort of the gig is up, so they file a sexual harassment lawsuit, and they did something for which possibly they could be disciplined for, but then in sort of a preemptory move, they file a lawsuit, they're off, and now they come back and we should have disciplined them before, but they were off, so we waited, and now it looks like retaliation. So again, tale of two cities here. I'm not sure which of the two is the accurate one. Do we have a problem employee? Do we have a department that's retaliating against a good employee? It could be both. It could be both. But it's very difficult once someone has filed a lawsuit, unless you've got your ducks in a row. And we have seen departments that do, Denver, and, one of the next cases, we're going to talk about it, but, it's very difficult. You got to be very careful about allegations of retaliation.
Look, and the standard is so simple, right? You must have a actual, legitimate, 100% independent basis for terminating somebody that has nothing to do with their alleged claim of discrimination, et cetera. So let's take the hard case. You have somebody who says the chief made sexual advances to me, all right, and I'm suing the chief and the department because I complained about it and nothing's ever happened. But since then, you develop let's call it a piss poor attitude. By the way, nothing has anything to do with this case, right?
Right, just hypothetically, right? No, hypothetically.
So, but then the employee develops a piss poor attitude and refuses to do their job, right? Well, I'm so mad I'm not cleaning. I'm so mad I'm doing this. I'm so mad I'm doing that. And then they're terminated as a result of their failure or refusal to do their job. They're terminated. And then they go out and claim, well, you discriminated against me because I complained. And we're saying, no, we were hearing your discrimination claim. Hopefully we were dealing with that and remedying that, but then you did all these other things. So I find that so common because this month, I'll be a little less specific, I have that exact issue. And the first question a lawyer should have for his clients are, do you have an independent, unrelated reason for the termination or discipline, or are you just trying to get back at the person? And if you have one or two or three things that in your policy manual, it says, if you do this, you can be terminated. And in fact, you've maybe terminated other people. You've treated them the same way, no harsher than this person. You should be okay. But you and I, and probably a lot of attorneys like us, get constant calls, I'm sure, that says, oh my God, we have somebody who we want to fire, but now they're screaming disability or race or gender or age or whatever. And my first question is, let me see the paperwork. What time, date, and place did they do something wrong where you told them you can't do this? What policy did they violate? What's the proof, right? What's your independent reason?
Right. Well, that brings us to our last case for the week, and that's the Denver case. And this is sort of a companion case to a case that we had talked about in the past. It was basically Charmaine Cassie and Delasha Allen both had filed race and gender discrimination claims against the Denver Fire Department. Both ended up being terminated. And cases are factually different. They were filed together. Allen's case was decided last September, and I haven't seen any appeals on that. I'm not sure what the status of that would be, but the court pretty much, said that there was no possibility of race discrimination, that no reasonable jury could attribute what happened to her race or gender. So, excuse me, that was the Allen part of this case. Cassie was a little bit different. And again, this kind of ties in with what we were just talking about the Washington State case, Cassie was put in the first academy, was it's called Academy 2018-02. Okay, so this was the second academy that they held in 2018. And about 14 weeks into the academy, she hurt her shoulder, and then she was washed out of the academy, but she was given a position in the next academy. That academy, she ended up hurting her shoulder again, as I understand it. But she wanted to go into the following academy, which would have been 2019-02, but that was a lateral hire academy. And I'm not sure how many weeks it was, but because she wasn't a lateral hire, she wasn't already firefighter 1 and firefighter 2. I think she might have been firefighter 1. They said, you really have to be firefighter 2 to get into the lateral hire. She was not happy about that. She felt like she should have been allowed into the firefighter 2 academy. So that was one of her allegations of discrimination, that she wasn't allowed into that academy. But the bottom line is she's allowed into 2019-03. Okay, so she gets into the third academy in 2019. And toward the end of that, this ended up wrapping up right around the end of 2019 and into 2020. She injured her knee. Now, she was able to finish the academy, but she also became pregnant. So she couldn't complete her on-the-job probationary period, which required her to work in 4 different stations. And, she was graded on that. That's actually where Alan had her bigger problems. She had problems in the academy, but she had problems on the probationary period as well, and she was washed out there. So Cassie completed the academy, but did not complete her ride-along time, her probationary ride-along time. And because she was pregnant, then once her knee was all set, she had time off due to pregnancy, and then she had a back problem that she doesn't allege had anything to do with work, but she had a back problem. And the department accommodated her apparently up until October of 2021. So in other words, she was on the payroll of the department from 2018 all the way to 2021. I'm assuming still as a probationary firefighter, because she hadn't gotten off probation, because she hadn't completed the tours on the apparatus. And she alleges that it was because of her race and gender that she was being discriminated against, and that also she had filed a lawsuit in 2020 with Alan, and she was terminated in 2021. So now we're in a situation like we just talked about with the Washington case, where she files a lawsuit, and then a year later, or in Washington it was months later, but in this case, she files a lawsuit in 2020, and 2021 she's terminated, and she's saying, "Oh, that's retaliation." And the court, court went through all of the allegations, went through your favorite test here, the McDonnell-Douglas test. And I mentioned this to you the other day. It almost seems like different courts interpret McDonnell-Douglas differently, but essentially, and you can read the case, you can read the quotes that I have from the case there. But essentially, the fire department had a legitimate reason for letting her go, that she was, she was not able to do the job. And how long can we continue to pay someone? It's 3 years, 4 years, 5 years. I mean, what's 2018, 3 years? She was getting paid, and, she hadn't really even worked on a fire truck yet. And she was apparently offered 29 different positions with the city. So it wasn't like they said, look, you're either a firefighter or you're nothing. Here's 29 jobs, and she didn't express an interest in any of them. And again, you can read here basically the department had a legitimate reason to terminate her employment, and again, you can read the quotes, but
and look, it is a hard discussion. I know, because I have this all the time. I've had it recently. It is a hard discussion with your client to say, listen, I agree with you. You have a completely non-retaliatory, independent reason to terminate this person. But the fact is, he, she, they have already alleged some sort of discrimination, and you already have maybe an ongoing investigation, right? And the comment I always have is, listen, you're buying a lawsuit. But if you, right, you know the lawsuit's coming, you're not going to prevent it, except maybe with a really good letter and the hope that they find an honest lawyer, all right? But we always know there's always some lawyers willing to sue. And so you know you're buying a lawsuit. On the other hand, my follow-up to that is, but you can't be afraid of it, because if you allow yourself to be abused this one time, when you have a true, legitimate, independent, substantial reason to fire someone, if you just cave in to, oh, you're discriminating against me, everybody's going to say that. And I told you about a conversation I recently had with someone, and I'm saying, well, why do you think you're terminated? And they gave a reason. I said, there's nothing wrong with that reason. They're like, well, I want to be able to sue. I'm like, well, and so I said to the person, I said, do you think you're being discriminated against? You have some reason you believe they got rid of you other than they just didn't like you? And he's like, oh, would that matter? Like, wait a minute, let's not make one up. If you have one, that's one thing, but don't make it up. If people have the right to terminate you, and if you give them a legitimate reason, they're going to do it. But I don't think employers should be scared. Look, you were buying a lawsuit, there's no question, but otherwise every employee is going to treat you that way, and you'll never terminate anyone, and you'll have a cesspool of some employees who should have been terminated, right? Just because they threatened you. So I get it as an employer. Nobody wants to be sued, but guess what? Right? It's the nature of our business, unfortunately.
Yeah. Well, one of the things I neglected to mention, she alleged race discrimination, gender discrimination. The court spent a lot of time talking about her disability discrimination claim, because she claimed that she had a disability. She sought a reasonable accommodation, which would have been another 7 months or so of unpaid leave. But there was no evidence that at the end of that 7 months that she actually would have been able to come back. She couldn't produce any sort of medical documentation that if she had the 7 months, all she did was she asked for 7 months, but she had no doctor's documentation that she would have been able to come back. And again, I'll read from the decision here. The plaintiff's accommodation request for 7 months of continuous unpaid leave is undisputed. That is not a plausible, reasonable accommodation. An employer does not have to retain a disabled employee on unpaid leave indefinitely or for an excessive time. Therefore, any request for a lengthy accommodation is unreasonable. Plaintiff has not presented evidence that she was otherwise qualified at the time of the alleged discriminatory activity. Therefore, defendant's motion for summary judgment is granted as to the ADA claim. So, again, a lot of moving parts in this one, but I really, hats off again to Denver and Denver Fire Department in terms of the way that they were able to handle this case. And, not to, certainly, Firefighter Cassie and also Firefighter Allen, who had, been terminated previously. People can, they can experience things differently. Everybody experiences things differently. You and I, we talk about the Red Sox and the Yankees, and you and I sitting together at Fenway Park, we're going to experience close plays differently. So it's not to say that
this year's Yankees, we're not experiencing anything close play.
This is, yeah. Even though the Red Sox are not doing well, at least they're doing well against the Yankees. So, but it's a good year, I guess you'd say, for the Red Sox. But the bottom line is, people experience things differently. So it's not to say that these folks didn't honestly experience it in a certain way, that they were the victims of discrimination. But from the department's perspective, the department documented their reasons both in the Allen case and in the Cassie case. And again, hats off. It's almost like a model for how fire departments should be documenting their employment decisions when it comes to these types of cases.
Right. And look, I find, we're going back to the physical issue, I find that many departments that I'm doing policies for do not have a policy that says you cannot stay on disability for X whatever. And even the volunteer departments are worse. The volunteer departments, a lot of them have a medical leave in their bylaws. And we could talk about, we're going to do a bylaw issue, right? A bylaw conference coming up. Yeah.
Yeah.
But one of the major bylaw issues is leaves. And if you don't state you may only be granted 6 months of leave at a time and no more than 24 months total or whatever, then somebody may legitimately claim, I've got a lifetime to come back. You can't get rid of me. So as we'll talk on the bylaw issues, leaves of absence or disability as an employer, you should have a policy that says you've got X days, weeks, months, and this is probably going to be a mandatory topic or subject of negotiation, right, with union. But after X time, if you can't come back, let's fill the position. And I think unions would be in favor of that after a reasonable amount of time.
Yeah. Yeah. And one of the questions becomes, what's a reasonable amount of time? I had a client that she had a shoulder injury, and her doctor, and at the time, this department had a hard and fast 18-month rule. But she hurt her shoulder, so her doctor recommended rehab. So she did that for 6 months, and they said, "Now we've got to do surgery." So then she had the surgery, another 6 months of rehab after that, and then the doctor said, "And now we're actually over a year. We're up to like 14, 15 months." And he says, "I got to go back in." And so, now you're putting somebody in a position where you come back and you're not 100%, knowing you're gonna hurt it again. Right. Or do you get it fixed? And, the hard and fast things, I think that, I don't know, there's got to be some sort of a reasonable basis and, for stretching it out. And in this case, I think there would have been, but unfortunately, she was forced to retire. She ended up going for the other surgery and unfortunately forced to retire. So,
yeah, understood. Okay, well, that was a really good week.
Yeah, a lot of interesting cases, and I got a couple more coming up for next week. I'm already aware of, so we'll be working on those as the week goes by. But that'll do it for another edition of Fire Law Roundup. Brad, thank you.